Hello, everyone. I'm Brandon. Welcome to another TestMax presentation. Today, we're going to be talking about how to read like a lawyer. I went to law school. I practiced law for a couple of years, so I learned how to read like a lawyer. And yes, I know all of you know how to read, and you have been reading for a long time, and you have probably read very difficult things as an undergrad and been able to comprehend them. But the way that lawyers read is specialized. Lawyers read from beginning to end of their careers. You start in law school and you do not stop until you are retired at 65. I did not wear glasses before I went to law school. I cannot see a thing after I went to law school. That doesn't mean you shouldn't go to law school. You may have to end up getting laser eye surgery after you're done. However, the point is you're going to read a lot. And you have to be able to pull out what's important from what you're reading. And you have to be able to do it quickly. So that's what we're going to be talking about today. A few housekeeping items that I would like to mention before we get started. One is that we have a brand new book coming out. I helped to write this book. Hopefully a link will pop up in the chat in just a second that will take you to that book. It's 33 Common Fallacies. We're actually going to talk today about how being critical of arguments is incredibly important on the LSAT. It's also incredibly important in law school and as a lawyer. And that book, and there is a link in the chat for you to take a look at it, that book takes you through the 33 most common ways that arguments are screwed up on the LSAT. And so that's very, very helpful. It's helpful on a number of different question types. And like I said, it's also helpful as you are becoming a lawyer and you're trying to identify what's wrong with arguments, both your own arguments and the arguments of your opponents. So definitely take advantage of that. Also, we recently, a couple of months ago, started our podcast, which is called The Legal Level. We have a new episode that should drop very soon, maybe today or tomorrow. And it's a really fascinating episode. So we interviewed, I and my podcast partner, Yelena, who is also an LSATMax instructor, interviewed Professor Ronald Sullivan. He is a professor at Harvard School of Law. He runs their Innocence Project. He's secured the release from prison of somewhere around 6,000 wrongfully convicted defendants, which is awesome. We had a very wide-ranging interview with him, which will probably be split up into two parts. He has some famous representations in his history as well. He represented the family of Michael Brown. If you remember, that's about when the Black Lives Matter protests started, was in 2014. Michael Brown was shot by a police officer in Ferguson, Missouri. Ronald Sullivan represented his family in a civil suit and helped them receive compensation. Professor Sullivan also represented Aaron Hernandez, which many of you may know was a Patriots, I believe, linebacker. He was convicted of murder. He committed suicide in prison and was later revealed to have severe CTE, which is brain damage from many hits over a career playing football. And he also represented, and this caused some controversy, he represented Harvey Weinstein. And so we talked to him about those representations. We also talked to him about the Black Lives Matter protests recently, what should be done with regard to policing and prison reforms and things like that. So it's really fascinating, and I hope you will take the time to listen to it. I see Bud says, Professor Sullivan did a great TED presentation. Yes, I saw that presentation. You should check that out. So that said, why don't we get started and we will talk about, oh, he was a tight end. I'm sorry, I messed that up. He was not a linebacker. Shows what I know. All right, so this is going to be the kind of presentation where I'm going to ask for your participation. So the ways that you can do that, you can type your answers into the chat box, although there are a lot of people here, and so I may miss stuff that goes by in the chat box. You can also raise your hand in the participants box and I can call on you. So when I ask for participation, that might be the best way to do it. There's also a Q&A box if you have questions either on what we're talking about right now or on law school, practicing law, your applications, that kind of stuff. All of that, you can type in questions into the Q&A box and I'm happy to answer them at the end of the presentation. So why don't we get started? I'm going to share with you my screen. That's not how I'm going to do that. To go to Zoom first, share content. All right, so let's talk about reading like a lawyer. And first of all, let's talk about what lawyers read. So if you're a lawyer, if you want, you can read the normal stuff that people read, like books and newspapers and stuff like that. But in law school, there are a number of things that you're definitely going to have to read. So let's talk about what you will read in law school, what you will read as a lawyer, and then we'll talk about how lawyers approach those types of things that they read. So most commonly, what you're going to be reading in law school is case books. Those are the textbooks of law school. They are big, they are heavy. The reason they have their own name, that they're not called textbooks, rather they're called case books, is because most of it is not material that's written by the author of the textbook. Instead, what case books include is usually at the beginning of each chapter or unit, you're going to have an introduction that's written by the person or the people who wrote the case book. But that's just going to give you a broad idea of that area of law. And then most of what you're going to read in case books are excerpts from judicial opinions. Judicial opinions are kind of the lifeblood of legal reading. It's what you read most when you're in law school. It's also what you will read most when you are an attorney. And what a judicial opinion is that a judge, or really the judge's clerk or clerks, will write out the arguments of plaintiff and defendant in a particular case, and then we'll decide which of them is right and which of them is wrong. Now, some of these come from lower courts. So there's two systems in the court. It's a little more complicated than this, but basically we have two court systems in this country. We have each state has its own set of state courts, and then we have a federal court system that governs the entire country. And they tend to work on a little bit different issues. I'm not going to get into a lot of that right now, but I just want to talk about the kind of opinions you'll read. So there is the lowest court in each of those systems. With state courts, sometimes they're just called state court or trial court. Sometimes they're called superior courts. With federal courts, the lower courts, the ones that conduct the trials, you have a jury, and this is true of those trial courts in state courts as well. Those are called district courts. Those are the lowest courts on the judicial food chain, I guess is what you could call it. Most of the opinions you read will not come from those courts, although some of them will. The reason for that is that most of what trial court judges do doesn't require an opinion to be written. Instead, they confront the same legal problems over and over again. The jury makes its decision. And if there are issues that are disagreed over, most of the time those issues are often dealt with like during a hearing where the lawyers for each of the parties will go before the judge. And the judge will just make his or her ruling right then and will say who wins and who loses. Most of the opinions that you're going to read, the judicial opinions you're going to read, come from the two higher levels of courts. And in both of the, well, in the federal court system, they call appellate courts, the ones that are in the middle, above trial courts but below Supreme Courts. They call those circuit courts. In state courts, the courts that are below the Supreme Court but above the trial courts are generally called appellate courts. You'll get a lot of appellate court opinions. Those are very common. And then you'll also get a lot of Supreme Court opinions. So there's the Supreme Court of the United States, which most people have heard of, but every state has its own Supreme Court as well. And so if you're dealing with issues of state law, you might be reading an appellate court or a state Supreme Court opinion. If you're dealing with federal law, you are likely to be reading a circuit court opinion or a Supreme Court opinion, a federal Supreme Court opinion. And in these case books, that's a very long way of saying that's what you're getting in these case books, but you're getting nicely edited excerpts. Those opinions can be hundreds of pages long, but the author of the case book will pick out the parts that are important for you to read. You will read those parts in a chapter on a particular issue. They also include, case books very often include excerpts from statutes and regulations. Statutes are laws. They're passed by Congress when they're federal statutes. When there are state statutes, they're passed by the legislature of a particular state. These also can be hundreds of pages long. But in a case book, they'll pick out the parts that are important to the issue that they're discussing, that they're teaching you about. And so you won't have to pick through hundreds of pages of statute to find what you're looking for. Regulations, which you may have heard of, they call them rules and regulations. This is when agencies will write rules in order to flesh out a statute. So for instance, the regulations that people are most familiar with, Congress writes the rules about taxation, but the IRS has a whole bunch of regulations that they write in order to make it so that people can comply with the broad statutes that Congress is writing on taxation. So that's what a regulation is. It's when an agency that enforces a particular law writes out the rules to clarify how the law works. And you'll see a lot of that in these case books too. And again, it will be excerpts. That's the main stuff that you're going to read in law school. You will also often read law review articles. You may have read these even before you get to law school. A lot of law schools have many law reviews. So for instance, I went to UCLA, and UCLA has its own law review. And what a law review is that somebody, sometimes it's a student, very often it's a professor at the school, it might be a professor from a different school, will kind of summarize what a current area of law looks like, and then will often offer an opinion on how that area of law ought to be changed, what's wrong with it, how to do it better. So that's a law review article. Like I said, UCLA has a general law review, but there are also law reviews on particular areas of law. Like for instance, I remember there was one on patent law, patent law's inventions, and it was JOLT, the Journal of Law and Technology. And so if you're interested in that, then you might want to participate in that law review. And a lot of times your classes will assign you law review articles, or if you work on a law review, you might write a law review article yourself. I actually wrote one about criminal justice for one of the classes I took. The last thing that is a very common bit of, and I don't even know if I want to call it reading, it's a reference book. It's this monstrous, awful thing called the Blue Book. And we've got a picture of its ugly mug right over here. And the Blue Book is an overly long system of rules for how you cite things when you are writing a law review article, or when you're writing one of these things that we're going to talk about in a second, a memo or a brief. When you are writing, when you're doing legal writing, you have to cite your sources. And because lawyers are very fussy, picky people, you have to cite them in very particular ways. And so this book is, I think, a couple of 100 pages long, and it's very particular rules about how you cite everything, down to what font you're using, whether or not something is italicized or underlined, the way things have to be abbreviated. I know I'm not selling it. I think whoever came up with the Blue Book is a bad person. I hated the Blue Book. It made me miserable. I love law school except for the Blue Book. But whatever, you learn the rules, eventually they will become second nature to you. You won't need the Blue Book as much. That is mostly what you read in law school. Now let's talk about what lawyers read, because it gets a little bit difficult, it gets a little bit different, and the training wheels come off. So remember we talked about judicial opinions and how you'll have neat excerpts in your case books. Well, you'll see, and this is what you see in law libraries, that's this stuff right here. There are reporters, and these are books, court systems will publish them every year. So like, I remember in UCLA when I was there, there was the California Reporter. And I think that was the California court system, would publish all of the judicial opinions that come out, at the very least at the Supreme Court level and at the appellate court level. Well, these are the full opinions. Before we had the databases that I'm about to talk about, this was all or almost all the reading that lawyers did. You'd see a law library, looks very fancy, the books are very nice, but the books were very useful because those cases are what you use to make your arguments. And we'll talk about in a little bit how you use those cases to make an argument. But they're not excerpts, it's the full opinion. And so if you are looking for a particular issue, you may have to sift through 100 or more pages of opinion to find the information that you're looking for. Well-written judicial opinions will have, be divided into sections, will have like a table of contents, and will make it so that you can find what you're looking for fairly easily. Poorly written judicial opinions won't do that, and they will make it harder to find. Luckily, you don't have to do things by book anymore. You can search. Like I said, there are databases, which I will talk about in a second, but that's what a reporter is. That's usually what you're seeing, or one of the two things you're seeing when you visit a law office and you see a law library, you're seeing reporters. There are also codes, which look a lot like reporters, But instead of being full judicial opinions, instead they have the full text of statutes and the full text of regulations. So again, in casebooks, you would have neat excerpts of these, but when you're a lawyer, you're going to have to comb through this stuff and find the stuff that's important. Lawyers who have been around for a while, and especially lawyers who are like senior partners at a law firm, they don't have to do this stuff as much. One is because they learn kind of the body of case law, and it only changes at the margins usually as time goes on. But also because junior associates, that's their job. You sit in the basement and you do legal research. You read through opinions and you find stuff that's going to help your team win the case that you're trying to win. This stuff is now available in databases. The two most commonly used ones are LexisNexis and Westlaw. In fact, when you get to law school, you'll likely find that one of your fellow students is a representative of LexisNexis, another one is a representative of Westlaw, and they do battle to try to get you hooked on their system before you become a lawyer. These systems are very expensive. When you're a lawyer, you're going to be paying thousands and thousands of dollars a year to either LexisNexis or Westlaw. And they are searchable databases that include all of the stuff like reporters, codes, stuff like that. It's all in there and it's searchable. And they also have commentary and indications that will tell you, which can be very helpful. A lot of times a piece of case law will get overruled, or a statute, the legislature will pass a law that will overrule a particular rule stated in a judicial opinion. And what's very helpful about Lexis and Westlaw is they will tell you when something has been overruled, because you do not want to cite case law that's not good anymore. And they'll tell you when the case law is not good anymore. So that can be helpful. This is not so much what lawyers read as what they write for other lawyers to read. So briefs and memos. When you are managing a case on its way through the judicial system, eventually you end up at trial, but there's a lot of stuff that goes on before trial, and there are actually issues that have to be settled at trial. And so a lot of times there will be a dispute between the parties, and you have to make an argument, a legal argument, why the dispute should go your way. Well, that legal argument that you submit to a court is known as a brief. And so you say, look, judge, you should rule for us on this legal issue, and here's why. And you cite your arguments and a bunch of case law that supports your point. There are memos. These are generally, and you'll learn to write these in law school. You're going to have legal writing your first year. You'll learn to write these. There are memos. Memos are internal documents. Very often a memo will be circulated when a party is trying to decide whether or not to bring a motion, whether or not there should be a hearing, whether or not we should fight over a particular issue. And the memo will give a summary of the law, both for and against the position we're thinking about asserting in that motion, and will often make a recommendation as to whether or not it's worth it to make the motion. You can actually get sanctions if you make motions that are frivolous. And so it can be dangerous to bring a motion just because you feel like you want to bring a motion. And so that's the written product that lawyers make, but it's for the consumption of other lawyers. So you will read briefs, you will read memos as a lawyer. A few more things before we start actually doing the business of reading like a lawyer. And yes, this is a lot. Have I turned you off to law school yet with all the reading? I hope not. Reading's fun. It's good for your brain. It's bad for your eyes, good for your brain. There are practice guides. These are very helpful. And what a practice guide is that it just walks you through the representation of a client on a particular matter. And so there are very general ones, like there are, I think it's called the Rudder Guide. They have them on different issues, but like there's a Rudder Guide for civil practice in California. And it's just, if you're going to sue somebody in California, there's a whole bunch of steps that go along with it. There's a whole bunch of things you have to do. And so the practice guide will lead you through each of those steps and give you recommendations on what you should do at each of those steps. And it will also point you to the relevant case law, the relevant judicial opinions, and the relevant statutes that you will need to cite as you're representing your client. And it's on all different areas of law. These next ones you probably have heard of, contracts. This is what, when you're downloading that app that's going to, I don't know, turn your profile pic into a piece of cheese with eyes and nose and a mouth. and it's 20 pages long and you just click I accept without reading it, that's a contract. You know what those are. Those are documents where two people agree to do things, and you can sue each other if you don't do the things that are stated in that document. Well, there are people who actually read those things. They are lawyers. And so especially if you're going to do like real estate law or something like that, contracts are very often part of what you do. There are also things that kind of operate like contracts, like a will or a trust. This is in estate law when people die, and lawyers read and write those things as well. Then there are ownership documents, mostly deeds and patents. So a deed is ownership of some piece of physical property that is very often real estate. You get a deed to real estate, but there's also deeds to other things. Like the deed to a car is often called title, but you might actually read one of those if you are a lawyer, or you might actually write out one of those if you're a lawyer. Patents are just ownership of intellectual property. So if I have an invention, I write out a patent. It states what my invention is and tries to show how it's different from what everybody else has done. And I can sue people if they use my invention by waving the patent in front of a court and saying, I own this thing. So all of that stuff is stuff that lawyers read. And it's a lot. Depending upon the area of law you go into, you may not read all of these things. But definitely these first few things, casebooks, law review articles, the blue book, that's mostly what you're going to be engaging with in law school. So far, so good. Now let's talk about the method that lawyers use to read some of this stuff. You may have heard of this method before for briefing a case. It's called IRAC. IRAC, I-R-A-C, stands for Issue, Rule, Application, Conclusion. A lot of judicial opinions are written in IRAC format, or they should be, because it's the best way to write out an argument like this. Briefs and memos almost always are written out in IRAC format. And I'm going to talk briefly, I'm going to give you guys a little bit of an example that we'll work through about how IRAC works. And then we'll try it out on a reading comp passage. We won't have time to actually do the questions on the reading comp passage. Oh, Lisa is asking, and let me just answer this. Is the blue book also available online? Maybe by now. When I was in law school a gazillion years ago, I don't think it was. I don't think it was on Lexis or Westlaw. Lexis, Westlaw has reporters' codes on their sites. Is this for all states? You can purchase different packages. So yes, they have all states, but you would not necessarily purchase all states. You would probably purchase a package that had to do with your state. So let's talk about IRAC. Like I said, IRAC stands for Issue, Rule, Application, Conclusion, and let's just define each of these. So the issue is the thing the parties are fighting over. And very often an issue is formulated as a question. And the purpose of the thing that you're writing is to answer that question. And ultimately, the question will be answered here at the conclusion. But first you want to state the issue. What exactly is it that we're fighting over right now? And again, in a second, I'm going to give you an example that we'll work through. The rule is how you decide the issue. So there should be, it might be part of a statute, it might be a rule in a judicial opinion, but there should be a rule that governs the particular issue you're arguing about. Sometimes the issue itself is which rules should apply. And that can be difficult, and it gets kind of meta because you have the rules about the rules. That's a lot of civil procedure and evidence talk about stuff like that. But there should be a rule that governs the situation. The meat of legal writing comes here in the application. And what you're doing in the application is that you're taking case law and you're showing, well, at least if you're writing a brief, which you're trying to persuade the court that your position is right and your opponent's position is wrong, you're taking old case law. And the case law that comes to the conclusion that you want, you're saying this case law applies in this instance. That's analogizing is what we call that. The case law that's bad for you, the case law that comes to the conclusion you don't want to come to, in a brief, you're distinguishing. You're saying, look, okay, that case law is great, but it actually doesn't apply here because our situation is different. We call that distinguishing. And so those are the two basic things you're doing as you're doing application. You are showing that the case law that comes to the conclusion you want is relevant to this situation. You're showing that the case law that comes to the conclusion you don't want is not relevant to this situation. And then ultimately at the end, you say, look, judge, you should rule for me. And that's your conclusion. So let me give you an example and we'll just think about it. So let's say you're a plaintiff and you have this friend and your friend asks to borrow $50,000. And your friend says, I promise that I will pay this back to you in 1 month. But what your friend does not tell you is that your friend knows he is going to lose his job tomorrow. And he has no savings and no assets. Not surprisingly, with this scummy friend of yours, you're going to end up going to court. Because what you are going to argue when your friend doesn't end up paying you back is that you have been defrauded by your friend, that your friend has committed fraud upon you. Well, the issue in this case before the judge would be, is this situation, I'm not going to write the whole thing out again, where somebody asks you for money, promises to pay you back, but seemingly is not going to have the funds to pay you back, is this situation fraud? The rule about fraud is more complicated than this, or in most jurisdictions it's more complicated than this, but it looks something like this. The defendant made a knowingly false statement. And the plaintiff relied upon that statement, and the plaintiff was harmed as a result of that reliance. So that's the issue, that's the rule. So as I'm trying to do my application, what I'm looking for, if I'm plaintiff, is something with the closest facts that I can possibly get where the defendant in that case was found liable for fraud. And so if I can find a case that looks exactly like this, there was some guy, borrowed the same amount of money, knew he was going to lose his job, did not pay it back, and was found liable for fraud, that's a case that we call on point. And that is a case that would be very helpful to your situation. What you're worried about, if you're plaintiff, is case law that goes the other way. A case where the same thing happened. The guy knew he was going to lose his job, asked for money, promised to pay it back, and yet the court found that he was not liable for fraud. And so in that case, that would be a case that's very much on point, and it would be very worrisome for you, because if you cannot distinguish your facts, then you're probably going to lose the case. So what we have to do generally is something that's more difficult than that, because it's almost never the case that you're going to find case law that looks exactly like your case law. Instead, there will be something a little bit different. And as you're doing your application, you are showing that the stuff that is a little bit different, if it's case law that's good for you, if it comes to your conclusion, that it fits your situation. If it's case law that's bad for you, you're distinguishing it. And that's application. So knowing how this stuff works, I would think that the main pieces of argument would be here. Knowingly false. It's one thing to make a false statement about something that has already happened. But I think it's very hard, and I actually think in a situation like this, the defendant would probably not be found liable, because making a promise to pay, it's kind of hard to say that that statement is knowingly false. Maybe this guy is going to get a job the next day, and he's hopeful about it. Maybe he thinks he's going to win the lottery. Maybe he will end up winning the lottery. And so we don't have the case law to do the application here, but I would think that in a suit for fraud, a promise like this, the defendant would be very likely to walk away. That doesn't mean that the defendant wouldn't have any liability on another theory, but when you're talking about making a knowingly false statement, I think that would be hard to prove in this situation. Fraud is more for like, oh, hey, I know this car doesn't have any defects when I actually knew the car had defects and I sold it to you anyway. That's an easy case of fraud. Something like this, I think, would be a harder case of fraud. However, if you were the plaintiff, what you would say is, well, I've got this case law, it's on point, and the conclusion is, yes, the defendant committed fraud. So that's the basic process that you're engaged in. Now we're actually going to look at a reading comp passage, and this is where I would like to have some participation. I'm just going to read this passage in full, and then you guys can do the IRAC for me. I'll ask each of you, what's the issue, what's the rule, what's the application, what's the conclusion, because it's all here. We won't have time to do the questions, but we will do a couple of logical reasoning questions in a second. This is actually about the law, which lots of reading comp passages aren't, so let's enjoy. Individual family members have been assisted in resolving disputes arising from divorce or separation, property division, or financial arrangements through court-connected family mediation programs, which differ significantly from court adjudication. When courts use their authority to resolve disputes by adjudicating matters in litigation, judges' decisions are binding, subject only to appeal, formal rules govern the procedure followed, and the hearings are generally open to the public. In contrast, family mediation is usually conducted in private, the process is less formal, and mediators do not make binding decisions. Mediators help disputing parties arrive at a solution themselves through communication and cooperation by facilitating the process of negotiation that leads to agreement by the parties. Supporters of court adjudication in resolving family disputes claim that it has numerous advantages over family mediation, and there is some validity to this claim. Judges' decisions, they argue, explicate and interpret the broader social values involved in family disputes, and family mediation can neglect those values. Advocates of court adjudication also argue that since the dynamics of power in disputes are not always well understood, mediation, which is based on the notion of relatively equal parties, would be inappropriate in many situations. The court system, on the other hand, attempts to protect those at a disadvantage because of imbalances in bargaining power. Family mediation does not guarantee the full protection of an individual's rights, whereas a goal of the court system is to ensure that lawyers can secure all that the law promises to their clients. Family mediation also does not provide a formal record of the facts and principles that influence the settlement of a dispute. So if a party to a mediated agreement subsequently seeks modification of the judgment, the task of reconstructing the mediation process is especially difficult. Finally, mediated settlements divert cases from judicial consideration, thus eliminating the opportunity for such cases to refine the law through the ongoing development of legal precedent. But in the final analysis, family mediation is better suited to the unique needs of family law than is the traditional court system. Proponents of family mediation point out that it constitutes a more efficient and less damaging process than litigation. By working together in the mediation process, family members can enhance their personal autonomy and reduce government intervention, develop skills to resolve future disputes, and create a spirit of cooperation that can lead to greater compliance with their agreement. The family mediation process can assist in resolving emotional as well as legal issues, and thus may reduce stress in the long term. Studies of family mediation programs in several countries report that the majority of participants reach a full or partial agreement and express positive feelings about the process, perceiving it to be more rational and humane than the court system. Okay, so first of all, and now it's participation time, you guys tell me, what is the issue here? What are we trying to decide? And you can raise your hand if you would like to tell me what the issue is. I see Tatiana has already raised her hand. So Tatiana, go ahead. I think you need to unmute yourself.
Hello,
Hi.
Branden, do you hear me?
Yes, I can.
Hi there. Okay. Well, it seems to me that the issue is whether family mediation is a better way of resolving family matters than just the regular, court system. That's what
I
I
think
see.
that's exactly right. So I think
Oh,
the issue here, if we were to present it as a question, which an issue often is family mediation or court adjudication better in settling these family disputes? So
right.
yes, I think that's exactly right. Thank you,
Okay.
Tatiana.
Thank you.
All right. So we've got the issue, and I'm going to write the issue down just so we have it all out here. The issue is court adjudication or family mediation better? This next one is hard. The rule is in here. It is stated very briefly, and they don't say, here is the rule. But can anybody find the rule? What requires us to make our decision? And in fact, I'm going to be nice, and I'm going to tell you, pretty much all of the legal analysis is in the last paragraph. So what is the rule of decision here? How do we determine between court adjudication and family mediation? And if you would like to raise your hand, I see Lisa has her hand raised. Lisa, can you hear me? I think you're going to have to unmute yourself.
Hi, Branden.
Hello. Go ahead.
I see that the decision is that family mediation is better suited for family law.
So I think you have found the conclusion. And I think the conclusion is that family mediation is better suited. But I don't think that's actually the rule that we're using to get there. And this one is tough. And this is always, I remember when I was in my 1L legal writing class, we spent an entire hour trying to find the rule in a particular decision because they weren't being cool about it. So I think you found the conclusion, which is very important. I see Gabby has her hand up. So let me ask Gabby if she sees the rule. Gabby, do you see the rule?
Hi, can you hear me?
I can.
Hi, is it that it is more successful in resolving emotional as well as legal issues?
If what you're pointing out is this, I think you are right. I think this is the rule. And let me explain why I think this is the rule. It constitutes a more efficient and less damaging process than litigation. Sometimes the rule is not easy to see on its own, but when you see that the application is putting the rule into effect, that's when you know that you're dealing with the rule. And if you look at all of this evidence that comes afterward, this is where I think the application happens. And I think knowing that it's applying this statement, this broad statement, shows you that that statement is the rule. And so it's a two-part rule. It's more efficient. That's one of the bases of decision, and it's less damaging. Here they're talking about how efficient it is. And so now I'm getting into the application. But look, it's efficient for a number of reasons. You enhance your personal autonomy and reduce government intervention. You don't have to have the bureaucracy of government telling you what to do. You're just making decisions among yourselves. So that's more efficient. I think much of this stuff is also talking about efficiency. You have skills to resolve future disputes. You're not going to have to go back to court. You're not even going to have to go back to mediation because you're going to have the skills to resolve future disputes. So all of that is talking about how efficient it is. Then we get down to some of this other stuff, and I think it's getting at the second part of that rule, that it's less damaging. Look, it resolves emotional as well as legal issues. Well, that's less damaging. If you're resolving emotional issues, that's less damaging than going to court and fighting over stuff and spending a bunch of money on fighting over it. I think this is very optimistic about family mediation, but it may reduce stress in the long term. That's less damaging. Then we've got a study. And this is where I think we can really see that we have the application of the rule going on. We have evidence from the real world showing that this is less damaging. participants, the majority of them, reach a full or partial agreement. I think that shows that it's efficient, it's working, and they express positive feelings about it, perceiving it to be more humane, which I think is very big, than the court system. So all of this stuff down at the bottom, I think, is the application. The tough part, I think, is identifying this guy right here is the rule. It's a broad statement. It's more efficient and less damaging. And then the application is, look, here are all the ways. Here is the proof showing that it is more efficient and less damaging. So just to be clear, I think we have pretty much almost all of the IRAC happening in the last paragraph. And this is common in judicial opinions as well, where you'll get kind of like a broader survey of the law, but then the real issues and the real meat of the decision comes toward the very end. So this is the conclusion right here, to be clear. This guy right here is the rule, and then all of this stuff afterward. This is the application of the rule. It's a little bit different than it looks like in a judicial opinion, but that is how that works. And then we identify the issue. I don't know that they ever state it directly, but when we're talking about one better way of doing things, one worse way of doing things, the issue is, what is the better way of doing these things? All right, so that's IRAC. That can be helpful in reading comprehension, depending upon the passage that you're doing. But we should also, before we are done here today, talk about how reading like a lawyer is helpful with logical reasoning. So logical reasoning still has arguments, but they're much shorter than reading comprehension. And so it's generally not the case that you're going to be able to do an entire IRAC analysis on one of those arguments. Although very often they're applying rules to come to conclusions. And so sometimes it is possible that you have all of the features of IRAC within a logical reasoning passage. But I think they're less testing that ability than they're testing what is a narrower but extraordinarily important capacity for you to have as a law student and as a lawyer, which is to be critical of arguments. What's so weird about the LSAT, what tends to throw people off, is that you have for years been reading things that you're supposed to learn from. And yes, I think often your professors tell you, well, be critical of what you're reading or think for yourself, but they don't feed you garbage. On the LSAT, they feed you garbage. They feed you crappy arguments. And they're testing your ability to see through those arguments, to see what is wrong with them. And an incredibly important skill, like I said, not just in law school, but for lawyers, is to be critical of arguments. Here's why. When you are arguing with opposing counsel over something, you want to be able to find the weaknesses in their arguments and exploit them. So it's very important to be critical of your opponent's arguments, but your opponent is going to be doing the same thing to your arguments. And you need to be prepared for the attacks that are coming on your arguments. And so you have to be critical just as much, if not more, of your own arguments as you are of the arguments that you're getting from opposing counsel. And so that's kind of, and we're going to do an error in reasoning question, a strengthened question, and a weakened question. With a strengthened question, I think that's what you're doing. You're being critical of your own argument. You're trying to patch it up. With a weakened question, you're being critical of your opponent's argument. You're trying to tear it down. But the process is the same regardless. And here is the process. Here is how you are critical of an argument, is that you want to show that the premises don't actually support the conclusion. And the way that you do that is you accept the premises as true, and you think critically and often creatively about how the conclusion might still be false, even if the premises are true. And so we have a couple of examples here, and we're going to read the arguments in the stimulus, and then I'm going to ask you guys to brainstorm. How could it be true that the premises are true and the conclusion is false? Show me why the premises don't actually support the conclusion. Once we've done that process, what we're going to find is that we kind of have the answer in hand already. So let's do this. Here we have an error in reasoning question. The politician's argument is most vulnerable to the criticism that. Politician says, from the time our party took office almost 4 years ago, the number of people unemployed citywide increased by less than 20%. The opposition party controlled city government during the 4 preceding years, and the number of unemployed city residents rose by over 20%. Thus, due to our leadership, fewer people now find themselves among the ranks of the unemployed, whatever the opposition may claim. What do you think? Are you voting for politician with this record of success? Let's just write out what's going on in the argument here, and you guys tell me what is so very, very wrong with this argument. The conclusion, specifically, is this thing right here. Thus, due to our leadership, fewer people now find themselves among the ranks of the unemployed. Now, fewer unemployed. And look, the mayor is saying, well, the opposition, before we got into office, unemployment was up more than 20%. Well, we have done so much better. Unemployment is up less than 20%. Does that guarantee the conclusion? Does that support the conclusion that fewer people are unemployed now than they were when the politician took office? And let me answer here. I think Carrie has her hand up. Carrie, I'm going to call on you. I think you may need to unmute yourself.
Yep, I just did. Hi.
Hello. How you doing?
Well, I guess what I would say is that there's other outstanding reasons why the unemployment could go up. There could be more job opportunities. So the correlation versus causation isn't quite exactly the argument that they could prove. More jobs could be out there. So just because they took business or took over the government doesn't actually mean.
So I think you're identifying something that would be important if you were determining to vote for these people, which is whether or not their policies are creating a certain situation, which I think would be important, but I think we have a much more fundamental problem here, and I think it's almost a math problem. Does anybody see the math problem that's happening?
Statistic-wise?
Yes. So I see Andrew is saying the math doesn't work like that with percentages. So let me just, and thank you, Carrie, let me just put some round numbers to this. This is actually a horrible, horrible, terrible argument. This is an argument that, in fact, is so bad that if the premises are true, the conclusion must be false. Let me show you why. So let's say, I don't know, when the opposition came into office, 100 people were unemployed. Well, they said greater than 20% unemployment went up. So let's say, I don't know, well, let's just call it 20%. If unemployment went up by 20%, what we have at the end of the time of the opposition is 120 people unemployed. This politician is bragging about the fact that, hey, you know what? We had unemployment go up by a smaller percentage. So now we have 120 people unemployed, and let's say, oh, we're doing so well, unemployment has only risen 10%. Well, that's actually another 12 people unemployed, which means there would be 132 people unemployed. This guy's conclusion, to be specific, is that this number is smaller than this number. That is false. That number is actually larger. The premises that this guy has given us guarantee that there are more people unemployed now than there were, not less. And so That's why this argument is so very bad, is that it is using these numbers so terribly. I see a couple of people in the comments have identified that problem. And that's, I know all of us went to law school because we don't like math, but sometimes on the LSAT we are getting math problems. And sometimes when you're a lawyer, especially if you're like calculating damages and things like that, there are math problems involved. And so this is a terrible, terrible argument. Now that we know how terrible this argument is, why don't you guys have a look at the answer choices and tell me what you think is the right answer. You can shout it out in the chat box if you want to. I see Mary identifies the correct answer. D is the correct answer. The evidence cited in support of the conclusion actually provides more support for the denial of the conclusion. This argument is so bad that if the premises are true, the conclusion has to be false. So the conclusion is definitely not supported. All right, that one's a tough one. I think this next one, at least being critical of it, is a little bit easier. So here, we're being asked to strengthen this argument. We're being asked to support the argument. So still though, we're going to find what's wrong with it. We're going to ask ourselves, okay, I'm going to accept the premises as true. Why don't the premises actually support the conclusion? Once we figured out what that is, to strengthen our argument, we will find a fact that takes care of it, that will fix that problem. So let me read this argument. I would say this is pronounced galanine. I don't know. Galanine is a protein found in the brain. In an experiment, rats that consistently chose to eat fatty food when offered a choice between lean and fatty foods were found to have significantly higher concentrations of galanine in their brains than did rats that consistently chose lean over fatty foods. These facts strongly support the conclusion that galanine causes rats to crave fatty foods. So our conclusion is a causal statement. This is very common in strengthened questions. And it says galanine causes craving of fatty foods. And what we found is that when it came to those rats that crave fatty foods, they had more galanine in their system. The ones that were less likely to crave fatty foods had less galanine. So doesn't that just mean that having galanine in your brain causes you to want the fatty foods? Let's accept these statements as true. Sure, the rats that ate the fatty foods had more galanine. The rats that didn't eat the fatty foods had less galanine. Why might it not be the case that galanine is the cause? Does anybody want to take a crack at that? Let me ask here, I've got John. Oh, let's see. I don't know if you're raising your hand particularly for this question, John, but I've called on you if you'd like to give it a go.
Great. Almost called you professor, but yeah, great. Thank you, Branden.
You can call me professor. It makes me feel great about myself.
All right. So yeah, I mean, can you repeat the question just one more time? What you were specifically asking?
So what I'm specifically asking is, we've got these premises and we're going to accept them as true. We're going to accept the fact that the rats that ate more fatty food had more galanine in their brain. The rats that didn't eat fatty food had less galanine in their brain. And then we're going to try to determine why it's the case that that doesn't actually support the conclusion, that galanine is causing them to crave fatty food. So why might that not actually support that conclusion?
Right. So when I was looking over this, I just immediately chose, instead of D, what some people are saying in the chat, I actually looked at A first, just because it's specific. I mean, if I'm reading this correctly, it's saying that the craving for fatty foods really doesn't result in rats choosing certain like foods, which is basically what the conclusion is leading to. Is that how the way I should be approaching this?
So I would be worried about answer choice A, and answer choice A is actually a commonly wrong answer, specifically with causal arguments, and let me explain why. It is an outlier, or it's talking about outliers. And what an outlier is something that doesn't follow a particular pattern. And so here we're saying it doesn't invariably have this result. In other words, what that would be saying is sometimes You have a rat that has galanin in its brain and it's not choosing the fatty food. Well, let me give you the classic example of causation and see why outliers generally are kind of, well, I don't want to say irrelevant, but they don't do much to an argument when you're talking about an outlier. So the classic example of causation is that smoking causes cancer. I think hopefully by now, everybody who is watching this presentation agrees that that is the case. Smoking does cause cancer. There are people who smoke and don't get cancer. There's people who smoke their whole lives and don't get cancer. There are people who get cancer and have never smoked a cigarette in their entire life, even lung cancer. And so there's not a tight one-to-one correspondence. But when you're talking about a general causal relationship, you don't actually need that tight one-to-one correspondence for there to actually be a causal relationship. And so very often they will give you an answer like A to test your understanding of that, what an outlier has to do with a causal relationship. And generally outliers don't harm or help a causal relationship. They're just a fact of causal relationships that happen.
Okay.
So thank you for that. I think that's a good point to bring up. But
Thank you, Branden. Thank you again.
My pleasure. But let me give you my thoughts on this. And so, and maybe somebody can type it into the chat box if they have it. Well, I see galanin in the brain. I see these guys craving fatty foods. And I'm saying galanin causes the craving of the fatty foods. One of the very common flaws for causation, and I see, let's not scream out the answer choice until I ask you to scream out the answer choice. And I know it's not screaming, it's typing in the chat box. But let's hold on to it. But one of the common causal flaws is that an argument will have cause and effect reversed. And so it's entirely possible that instead of having galanin causing you to crave fatty food, instead the fatty food itself is putting the galanin into their brains or is raising the level of galanin in their brains. And if that's the case, then we have it backwards. We don't have the cause and the effect. We just have this situation. And note, they don't tell us when they tested these rats. If they tested the rats after eating and they found more galanin from the ones who ate the fatty food, well, maybe it's because galanin causes you to eat fatty food, but it also might be because fatty food has a lot of galanin in it. And that would be a problem for this. And so as I'm thinking about how could those premises be true and yet the conclusion is still false, that's how. That gets us to, and what is the correct answer, is actually D. The rats that preferred fatty food had the higher concentrations of galanin in their brains before they were offered the fatty foods. That fixes that problem. That fixes that issue. And note, in the, like I was saying in the stimulus, they don't ever tell you when they're testing the levels of galanin. If they're testing it after they're eating, then there's every reason to believe that eating the fatty food, regardless of what caused it, is what actually causes the higher levels of galanin. So Fradine asks, how do we know that though? How you know that is you buy 33 common fallacies and you're actively looking for them in each argument that you're reading. So you will see reversing cause and effect over and over and over again. And you have to ask yourself, do I know that the cause came before the effect here? Well, we don't actually know that. They didn't give us that information. And so that's, I think, what's difficult about the LSAT. They tell you, oh, you don't have to memorize anything. Well, that's actually a lie. There are lots of things that you should memorize and you should be actively looking for. As I'm reading a causal argument, I have to have at the front of my mind, cause and effect might be reversed. It is possible. Do you like how I sold you a book in response to that question? Unfortunately, we don't have time for this last question, but the process is the same. We would be critical of the argument, and it's a weakened question, and we would just be looking for the answer that confirms that what we were critical about the argument was indeed true. But unfortunately, we don't have time to get to that. I am going to answer your questions in the Q&A box in just a minute, but let me just tell you about what you can get with each of these packages. There's a payment plan. We know it's expensive to study for the LSAT. You don't have to dump all of the money that you have into LSAT prep right at this moment. You can also get a look. You can take the June 2007 LSAT for free if you download the LSATMax app or go to lsatmax.com. You can get a little bit of a look at the stuff that we provide there without signing up for anything. So feel free to do that regardless of whether you're going to sign up. But let me just tell you a couple of things that I think sets LSATMax apart. And those few things are, it starts out with giving you lifetime instant access. Studying for the LSAT does not happen overnight. I happen to think that to study for the LSAT completely takes about 180 hours. You might spend 20 or 30 hours a week and do it in a shorter period of time. You might spend 10 hours a week and do it a longer period of time. But studying for the LSAT is something that takes a while, and we're not here to get you on a subscription plan and to bleed you dry until you are done studying for the LSAT. Instead, once you become part of the LSATMax family, you're part of the LSATMax family until you are finished with the LSAT and never take a look at this stuff again. When you sign up, you're going to be given a study schedule, usually starts about 4 months out from the date of your test. And you're going to be working through the study schedule alongside a bunch of other students who are studying for the same exam. And so what we've tried to do is to create an online community of people studying for the LSAT. So you'll be working through about 100 hours of lesson videos that come with a bunch of real LSAT practice questions, drills, flashcards for you to work through. There are real-time message boards appended to each of those questions. So if you have a problem with a particular question, you can ask about it on the message board, an instructor will respond. Students often talk to each other on the message boards about the questions, so you're not alone while you're studying. We also have personalized support. Again, as long as you're part of the LSATMax family, we're here to try to help you get the score that you need. Reach out to us and we'll try to get you the help that you need, whatever your issue is. A couple of other things that I think are great. We have often more than weekly office hours. This is when one of our 99th percentile instructors will lead you through a particular question type or concept on the LSAT. A couple of other things, we're always tracking your performance, whether you're taking a full practice exam or just doing questions. That's especially useful toward the end of the course when you're trying to catalog your strengths and weaknesses to make sure that your study is efficient and effective. Our interface looks just like the normal LSAT interface, so you don't have to learn how to take the exam while you are taking the exam on test day. And finally, we have a higher score guarantee. If you don't do better on test day than you did on your first diagnostic exam, send us your score. We will give you your money back. So those are the things that I wanted to tell you about LSATMax. I hope that I will see you guys either in the course or in one-on-one tutoring, but now let me answer your questions in the question and answer box, and I will answer them in the order they were received. Brianna or Brianna, I'm sorry, I don't know which. My sister's name is Brianna. She's very particular about it. Asks, what are your thoughts on the lsat-flex test? Have they created a score scale? My understanding is that it is scored very closely to the normal LSAT, by which I mean the percentage of questions correct on the LSAT-flex will get you a similar score as that same percentage of questions correct on the normal LSAT. The only major difference is that instead of there being 4 scored sections, 2 logical reasoning, 1 reading comp, 1 logic games, they took out 1 of those logical reasoning sections. So there's just 1 each of logic games, logical reasoning, and reading comprehension. And the scale is different. This is true of the normal LSAT. The scale differs from test to test, but it should be close. Georgetta asks, if you were to assign a number, how heavily is the LSAT weighted in applications 1 through 10? I've heard it's weighted significantly heavier than GPA, but I'm curious. What I have heard is 60-40. Zach is saying that it's 75 to 80%. I do know that it is weighted more heavily, the LSAT is, than is GPA. And there's a couple of reasons for that. One is that LSAC actually did a study that showed that it correlates, LSAT correlates with success as a 1L in terms of GPA better than undergraduate GPA does. So it's a better predictor of success. It's also just a lot easier for schools to interpret. A 160 is a 160 is a 160. The score is the same no matter who you are. When it comes to GPA, well, what was your major? How difficult were the classes you took? How, did you take professors who were pushovers and were open to grade inflation? The prestigiousness of your school. All of that stuff factors into your GPA. And so a 3.5 for one person might be radically different than a 3.5 for another. I hope that answered your question. Zia asks, I was wondering, what would you recommend for the student who has English as second language to improve on reading comprehension, especially with humanities and science passages? How to consistently improve on logical reasoning? So those are some big questions. A couple of things as far as reading comprehension. I think what you should do in the short term is every time you come across a word you don't know, you should write it down and define it and memorize it and know it, because those words will probably come back. It's also helpful, and again, these are larger discussions. I don't know how much we can do in this amount of time. It's also helpful to think in terms of argument structure. So it can be difficult to understand if they give you an experiment, for instance, in a science passage. It can be very difficult to understand the terms of the experiment. But an experiment is always a premise that supports a conclusion somewhere. And so if you're thinking in those terms, I think you can understand why you are reading what you're reading, even if you're not actually understanding every bit about what you're reading. How to consistently improve on logical reasoning? Well, if you're talking about improving in the section overall, timing is important. That includes skipping around in the section, answering questions that are less difficult before you answer the more difficult ones. I would say just generally the most important pieces of logical reasoning are argument analysis. Those are tested by methods of reasoning, argument structure, and main point questions. So I would master those. And then being critical of arguments is even more important. That's the questions we did today: errors in reasoning, strengthen, weaken, also strengthen with a necessary premise. So if you're doing that argument analysis stuff, practicing that, getting comfortable with those flaws, the 33 common fallacies, and looking for them in not just error and reasoning questions, but in strengthen and weaken and strengthen with a necessary premise question as well, I think that can help you. Yes. Willie asks, is there ever an instance where you would need to revert to the 100+ page long actual opinions instead of what the author of the casebook deems important? This is in regard to law school as opposed to practicing of law. I mean, I guess what I would say is that you will actually be forced to confront those in your legal writing class. So in your legal writing class, they'll teach you how to do legal research. And you probably won't actually have a casebook in your legal writing class. And that's separate and apart from the other classes like contracts, criminal law, property, torts. Those are your first year classes. Those teach you the substance of the law, like the theory behind it. Your legal writing class teaches you the skills you need to do lawyer stuff. And so legal research is part of that. And so you will read those, you will go through those 100+ page long opinions in law school. You would be unlikely to do that in one of your other classes, but you will do it a lot in your legal writing class. I hope that answers your question. Are these readings the same for both litigators and transactional attorneys, or can you talk about the differences? Well, when you get to be when you get to be a lawyer, you will do more heavily one or the other. If you're a transactional attorney, you will rely more heavily on reading contracts because you will be reading and writing contracts. But you will still refer to case law and you will refer to statutes to know how to do that. Because when you're drafting a contract, one of the things you're doing is you're drafting it to protect your client in case your client has to go to litigation over that contract. And so if you're the contract attorney, you have to know the law, which is contained in those statutes and judicial opinions, but you'll probably be more involved with the contracts. Now, if you are an attorney, a litigator who is suing or is helping someone being sued on a contract, you're going to have to read the contract because that's what you're fighting over, is the terms of the contract. But if you're a litigator who does stuff besides contracts, then contracts will be irrelevant to you. What about the bar exam? Bar exam is painful. The bar exam is, you do a lot of IRAC on the bar exam. So they're going to give you a fact pattern for the most part on the bar exam. You memorize the law, they give you a bunch of facts and they say, okay, tell us what the law says about these facts. And you know, if you're doing a torts fact pattern, there will be a car accident or something. And you're just being asked, what are the issues? You have to figure out what the issues are, and then you have to write what the law is about those issues and apply it. So it is a very IRAC-ish analysis. Are there any merits to using casebooks reporters now that people can use LexisNexis Westlaw? I think the only advantage to those is, at least for me, I prefer to read things on paper. I get exhausted and kind of confused when I'm reading them on a computer screen. But you can also print out what you get off of LexisNexis. I mean, casebooks and reporters. I mean, well, casebooks are not obsolete, because you're reading the instructional text in there as well, and you're reading the piece of the opinion that's important. So I don't think casebooks are obsolete. Reporters are kind of obsolete. Everything you get in a reporter and more is available on LexisNexis Westlaw. But it looks nice in your law library. You want to impress your clients. Is there training required to use LexisNexis Westlaw? Is it worth learning how to use them in advance? Yeah, you'll get training on it in your legal writing class. That will be a lot of the legal research that you do. You'll also, like I said, there's campus reps who will help you because they want to get you hooked on one system or the other. So if you have questions about it, you can contact a campus rep and they'll help you. Is it worth learning how to use them in advance? Sure, but you will learn to use them then. You'll, hit the ground running. If you have nothing better to do, I guess. Can you talk more about the 33 flaws reimbursement? I don't know. I got a message just telling me my students could get reimbursed. I would recommend that you, email the office if you're interested in that. I think it's support@testmaxprep.com, and they should be able to tell you about reimbursement for it. I wish I had more information for you, but I think if you just email us the receipt, we'll reimburse you. Any good books to read as a lawyer? I mean, if you're asking me, are there books that are going to help you read like a lawyer? I don't know. I mean, I'm sure there are books out there on how to IRAC things, but I don't have a recommendation for you. There's the difference between the red book and the blue book. I don't actually know what the red book is. I'm sorry, I wish I could answer that question. It looks like Gabby answered your question, but Charis, I hope I'm pronouncing that correctly, asked, does LSATMax provide practice tests? If you buy either of the two larger packages, you'll get access to all 90 prep tests that have been released in the modern history of the LSAT. The smaller package gives you access to 20 prep tests. A lot of these are, the textbooks are mailed out to you. I don't know too much about the administrative stuff. But I think they're mailed from California, so it shouldn't take that long if you're nearby. When is it worth going to law school? Wow, that's a big question. Is the law field currently overpopulated at the moment, in your unbiased opinion? Who says my opinion is unbiased? I have heard others warning not to go to law school unless it is a top 14 law school. No. No. Look, there are plenty of openings for lawyers. Is the field more saturated than it was 20 years ago? Probably. But look, the thing about top 14 law school is if you want to do big law, if you want to go to Jones Day or IREL in Manila and be the guy who's doing mergers and acquisitions for $180,000 a year right out of law school, then yes, you have to go to a top 14 law school. But the idea that it's not worth going to law school unless you go to a top 14 law school is dead wrong. And the people who tell you that are dead wrong. Plan out what life you want to have, and then find a law school that is going to help you get to that life, hopefully with a minimum amount of debt. So if you're interested in a particular area of law, there might be a school that's great for that area of law, but that is actually, ranked 50 or 60 or something like that. Or if you're interested in working in a particular smaller market, there might be schools that are, in that smaller market that are not in the top 14. So I think it is perfectly worth it going to law school. That doesn't mean you're guaranteed a job when you get out. I think you should definitely look at the employment rates of the schools that you're interested in and ask yourself, is this school going to help me to get a job? But the people who are telling you that it's not worth it to go to law school unless it's a top 14 law school are wrong. Andrew says, supposedly there was some confusion about scratch paper on the first lsat-flex. Any clarity after the June test? My understanding is that that was the first day. Some of the proctors, they hired a whole bunch of proctors and didn't train them well enough. And a bunch of proctors were preventing their students from using scratch paper, and you are definitely allowed scratch paper. My understanding is after the first day that was fixed, that they made it explicit to all of the proctors, you must allow your students to use scratch paper. So that shouldn't be a problem. We will get a refund for the book you mentioned at the beginning of the webinar if we are currently members of the program, correct? That is my understanding, yes. I hope I did not say that incorrectly, but that is my understanding. Larry asks, how much study time prior to the LSAT do you suggest? I think studying for the LSAT fully, starting from the beginning and getting all of the information you need takes about 180 hours, maybe even more. So the question is, you know, given your schedule, how long is it going to take you to put in 180 hours? Again, if you're putting in 25 hours a week of studying, that's different than if you're putting in 10 hours a week. But plan on about 180 hours and figure that whatever time is available in your schedule is going to be taken up by the LSAT. If we have used other platforms to take practice tests like the June 2007, is there a way to write in those scores without having to retake that diagnostic? I mean, I don't think so. You know, you answer the questions and we spit out a score for you. I mean, what I would say is if you've already taken the June 2007, then that's just not relevant for you. And you would, if you signed up for the course, you would get access to other prep tests and I would take those other ones. If you've been out of school for a long time, who do you recommend should write your letter of rec? If you have been out of school for 5 years or more, you can have business recommendations. That's a supervisor or a colleague. If you've been out of school less than 5 years, generally they want 2 letters of recommendation from an academic source, preferably a professor, although it can often also be an academic advisor or a grad student TA. And then sometimes they will let you write a third, which could be a business reference. How many hours would you recommend studying if you are not working 9 to 5? So Gabby studied 10 to 14 hours a day. Here's always my recommendation on the amount of time you put in. Put in as much as you can without burning out. And 10 to 14 hours sounds like a recipe for burnout. So I found when I was studying for the LSAT that I would get, and this was true of the bar exam too, I'd get to 6, maybe 7 hours, and then my brain just kind of shut down. And I wasn't getting any value out of it anymore. I was just exhausting myself and hurting myself. But it's different for everybody. Look, if you can study for 10 to 14 hours, and it will actually, you'll get more out of your studying in hours 9, 10, 11, 12, then fine, do that. But I think you have to know your own limitations and push yourself up to those limitations, but not beyond. Do you have any tips for getting yourself out of a testing rut? On one diagnostic, I scored in the low 170s, but in every one since, I've been in the high 160s, and I'm struggling to get over the speed bump back into the 170s. Every time I feel confident about it, I find I can't improve. Usually, I think that's a sign of burnout, you know, because when you've scored at a particular level, it's not an accident. And so everybody deals with burnout differently. So that might mean taking a couple of days off from studying. Obviously, if you're like right up against test day, it's hard to do that. But I would think that it would be a burnout thing. All right. I've been using LSAT flashcards as a study guide. Is that a good idea, or should I be using past LSAT tests to study? I would do both. I think that there are things that you need to memorize. For instance, the keywords for conditional diagramming are important to know exactly how those words, and flashcards can be helpful there. The common fallacies, I think, are important to know, and flashcards can be helpful there. But I think you also have to test that out on real LSAT questions. So I don't think it's an either or. I think you need to do both. If a person, minority, has a disability, does that weigh against them? No. I have 2 master's degrees, but the LSAT makes me appear inept. Well, a couple things that I would say about this. First of all is that with a doctor's note, you can get accommodations on the LSAT. So you might be able to get extra time. If it's a visual disability, you might be able to get like a paper test or, you know, a test that's formatted differently. So that's one thing. But the other thing is that you should write an addendum explaining to the schools that you're applying to your disability and how it affects you on the LSAT. But I would definitely, if you have a disability, I would ask for accommodations before you take the LSAT. Because the LSAT is not there to weed out people with disabilities. That's not what it's for. How do I not burn out from studying? Oh boy. Well, there's a lot of different things you can do. You know, one is to kind of have a break day every once in a while, and not just a break where you're like catching up on all the stuff that you didn't get done, but a break day where you are nice to yourself, whether that's, you know, going to the beach or buying yourself something nice. Meditation, having a meditation practice, exercising, all of these things are important. You really do have to do self-care. I know it sounds like squishy, touchy-feely when I talk about stuff like that, but I do think it is important because burnout can affect your performance. So I think you need to cope with it somehow. What is your thoughts on constitutional lawyers? Well, there's a couple of different things that are contained in your question here, which is there are like the ACLU constitutional lawyers. That's a great life to live. There are not a lot of jobs doing that. So the ACLU, for those of you who don't know, is the American Civil Liberties Union, and they tend to sue the government very often when the government is restricting people's civil liberties. And very often they're arguing about constitutional principles like the First Amendment, or when it comes to people who are incarcerated, the Fourth Amendment or the Fifth Amendment. But those jobs don't pay terribly well, and there aren't a lot of them. But there are lawyers, and constitutional issues arise all over the place. And there are lawyers who operate in the sphere of defamation. So they often call those the First Amendment torts, where somebody is saying something nasty and false about you and you sue them over that. And so a lot of people do that kind of practice. As far as doing constitutional law, that kind of ACLU stuff, it's great, but again, it doesn't pay a lot and there aren't a lot of jobs doing it. Thank you for the podcast. No, thank you, Carrie. I hope you enjoyed it. This doesn't look like a question, but it doesn't look like what no, I think this is wrong. So when I say the meat of the case, the meat of your IRAC analysis is the application, is the A part of the case. Because you're gonna have the rule and you can state the rule fairly quickly. Well, the rule is X. But then you spend pages and pages talking about, well, there was this case and, you know, they were found to have violated the rule and here were the facts in that case. There was this other case and they were found to have not violated this rule and here are the facts in that case. So the application is going to be the big part of your IRAC analysis. What is a typical average time frame to study for the bar exam? A lot of times people will start studying right after law school ends in like May, and then they will take the July bar, which is in mid-July. So it's about a 2-month process. In some ways, it's easier to study for the bar exam because it's mostly memorization, whereas the LSAT is a test of reasoning, which can be much more difficult because you're kind of rewiring your brain. So that's the typical average study time for the bar exam, 2.5 months. But it can take longer. How do you approach complex sentences? It seems like Gabby has it right. Break it up into parts and mentally translate, summarize it in easy language as you read along. Yeah, I mean, I think I kind of agree with that. Very often there are commas that are separating clauses in a sentence. And I think you can take care of them hopefully that way. For scratch paper on the LSAT-Flex, can you use lined paper? I don't know the answer to that question. I think it's supposed to be the normal, 8.5 by 11. And I think you get 5 sheets, but I don't actually know the answer to the question of whether or not you can use lined paper. Should we take the diagnostic straight through, or can we break up the section if needed? Well, if you want the best representation of your level of performance, then you should take it like you would take it on test day. Because if you take, if you're taking a 5-section diagnostic test and you take one section over 5 days, then you'll be fresh for each of those sections. Whereas on test day, you're going to take the 5th section after taking 4 other sections. So I would, if you want the most accurate representation of your current level of ability, I would take it all at the same time. All right, Khan Academy is free. Can you speak to how much better TestMax is? Well, I don't know a whole lot about the Khan Academy system, but what I do know is that with the Khan Academy, you're pretty much on your own with the information that they give you there. So that doesn't necessarily mean that it's bad, but if you want to be part of a team of people who are studying for the LSAT, and if you want help when you are studying for the LSAT, then I think signing up for TestMax is the way to go. So I don't know a lot about their system, but I do know that TestMax is entirely comprehensive. It covers everything that you're going to see on the LSAT, and it covers it in detail. And I think it's organized in a way, we kind of take you ground up from the basics of logic and argumentation and build upon it. And so, like I said, without knowing exactly how Khan Academy works, I think TestMax is an excellent system that really gives you the basis to understand how the LSAT works on a broad level and also on a specific level. Any advice on how to become quicker at LSAT games? There are a number of ways to do that. We're kind of running out of time here, but I'll give you my just kind of best answer to this question. One is that you should be picking the questions in your order. Very often that will mean doing the if questions in a game first, the conditional questions, because those can teach you about a game. A lot of times students don't do scenarios when they should. If you don't know what scenarios are, go and watch the Guru Games portion of the LSATMax course. That's where you take one rule or one variable and try out all the ways that it can work. That might take a little bit more time on the front end, but sometimes it opens up the questions and you can just rush through them. The last thing I would say is that you can use, and this is why I was talking about doing those if questions first, you can use information from a hypothetical that you create in response to one of those if questions, sometimes to answer a different question, but more often to eliminate wrong answer choices. If it happened in a hypothetical, it's something that could be true, and you can get rid of answer choices that are asking you what must be false on the basis of it. How do you get special accommodations? I would go to the LSAC website. There's a document that you fill out and that you get your doctor's signature, but you should look there. Unfortunately, we are about at the end of time. These are very great questions, but I'm not going to be able to answer all of them, unfortunately. So I'm going to have to let you guys go. I just want to thank you guys for showing up and asking all of these great questions and participating. I thought this was a really good session. Hopefully I will see some of you guys either in office hours or in tutoring, but regardless, I wish you the best of luck on your LSAT studies going forward. So thank you so much. Please stay safe and stay healthy and be well.